Hello friends, how are you? Myself is Dr. Jineswani. I am an advocate. Today we are going to discuss an important topic concerning prevention of corruption act. I want to clarify all of you that it is not very easier to have a bail on board concerning the prevention of corruption act. Whenever we are going to contest a bail, usually we got disappointment because ultimately we want a bail, but when bail is not inclined, we got disappointed. So, what to do in such a case? That is a basic concept. For this, we have to emphasize on the legal protocol, legal compliances, so that we could have remedy on board. Whenever we got trapped in a case under Prevention of Corruption Act, we are in the confinement, but our relatives got panic. How to get the bail? They used to enter in the premises of an advocate and used to insist, sir, we need a bail for our relative who is in confinement. What to do, sir? He simply suggests move the bail. But the primary question arises, is moving bail is the solution for you? Do you think? I think that it is not the solution. If you want to get the solution, you have to emphasize on the legal protocol and compliances. For this, you have to read the FIR first. Because when we are not able to understand the case, we could not contest the case on merits. So, first of all, we have to read the FIR and have to find out the section under which our relative is implicated. For example, he might be implicated as per section 7, he might be implicated as per section 13 of PCA. So, first find out this section. If he is merely implicated in section 7 of PCA, then find out the reasons why the benefit of section 41A CRPC or section 35 subclause 3 of BNSS is not given to him. As we know that if the offense is punishable with imprisonment up to 7 years, he deserves the benefit. But why the benefits are not given? Are the grounds real? Are the grounds hypothetical? Find out and mention the same in your bail plea. Got the point? Now we are coming on the next point. Then find out the exact role of the accused in the crime. Sometimes there's a difference between demand and acceptance. If the distance between the two instances are huge, then also take the said scenario as a defense point in the bail plea. Got the point? Now we are coming on the third stage, that is the recovery. From where the recovery is made, either from person or from property. If it is not from person of the accused, then it is beneficial for us. As per the observation of Honorable Supreme Court in an important case dated 17th of April 2000. And apart from that, we have to see the period of incarceration, the period during which the accused is in jail since the date of his arrest. And we have to simply state, in addition to all these points, that accused is innocent. There is no demand on his part, and apart from that, no work of the complainant is pending with him. And we have to specify the judgment of Honorable Supreme Court on that point, that is Neeraj Datta versus State of NCT. Judgment is pronounced by Honorable Supreme Court, which is cited as 2022 online Supreme Court page 1724. In that case, it is specified that if demand is not proved, the accused could not be convicted. And apart from that, mere acceptance, mere recovery cannot be a basis of prosecution of the accused. So we have to specify that one also, because we have to keep in our mind that the protocol of section 20 of PCA would not be applicable, because section 20 of PCA presumption would be applicable only when there is a trial. And apart from that, we have to emphasize that the accused is not having any previous antecedents, and apart from that, he is not having any criminal history. Charge sheeted is already, and apart from that, there is no requirement of any custodial interrogation because investigation and recovery had already been done. All the facts are subject to scrutiny of trial, and till then, keeping the accused in the confinement would definitely affect Article 21 of Constitution of India, because the basic rule is of bail, not of jail. We have to emphasize. And in canon of judgment, it is also specified by Honorable Supreme Court that bail is rule, jail is exception. Please be remember, and you are required to mention all these points in the bail. And apart from that, you have to specify that the accused, if released on bail, would not flee from justice. He would not tamper with the evidences, and apart from that, he will not misuse the liberty of bail. And for this, Honorable Court, if thinks fit, may impose condition as per section 480 subclause 3 of BNSS, and apart from that there is no violation of section 35 subclause 2 of BNSS, and that's why we have to emphasize that the arrest is illegal and it is done against the norms just to affect the life and liberty of the accused. And apart from that, we have to specify that the accused is ready and willing to be abide by the conditions to be imposed by the honorable court. Because we have to specify whether the accused is named in the FIR or not. If accused is not named in the FIR, in case we are having multiple accused on board, in that scenario, we may take the additional benefit. In case charge sheet is filed, we will take the additional benefit. In case you are not caught, means the accused is not caught red-handed, we will get the additional benefit. Apart from that, even though prosecution says it involves moral turpitude, but the key point is that the seriousness of the offense, pendency of multiple cases, apart from that, it involving a moral turpitude cannot be a ground to reject the bail plea. So, the key point is that, as observed by Honorable Supreme Court in judgment of Sumit versus State of Maharashtra, that is 2023, Live Law Supreme Court, page 373, bail is bail. If the charge sheet is filed, an accused is not required, even though offense is serious, he deserves a bail. So, in the said case, the bail plea is allowed, and apart from that, Honorable Allahabad High Court, in a case titled as Vijay Kumar versus State of UP, had allowed the bail plea. The judgment is dated 30th of June 2025. And apart from that, we are having the judgment of Honorable Allahabad High Court on the same point, that is Prashant Kumar versus State of UP. So, whenever we are going to make a bail plea, we have to remember all this point to have the proper remedy concerning the inclinement of the bail plea. So I think that I'm totally able to make you all understand about the topic in a very efficient and easy manner. So see you in the next video. Till then, Jai Hind, Jai Bharat.